Finally, let's tackle substituted service properly. The absolute last resort, under Article 105. How is it done?
Sedler describes it as the method used when all else fails. The court doesn't just give up. The idea is the court did everything reasonable to notify the defendant. If direct notice isn't possible, that's not the court's fault, as long as they follow the last resort procedures. Even if the chance of actual notice is low, doing substituted service properly has the same legal effect as personal service.
Well, so what are the actual methods?
Three main ones, often used together. 1, stick a copy of the summons up somewhere obvious in the courthouse.
Okay, public notice board style.
2, stick another copy on the building where the defendant last lived, worked, or did business.
Taping it to their last known door, basically.
And 3, publish a notice in newspapers circulating in Ethiopia. Sometimes methods 1 and 2 are used together, sometimes all 3, maybe even combined with registered post or service through another court. The hope is the defendant somehow finds out.
But the odds seem low.
Very low, which is why Sedler constantly emphasizes it's the last resort. The inefficiency is clear.
Understood. What about serving people outside Ethiopia entirely?
Article 108, first priority. If they have an authorized agent in Ethiopia, you must serve that agent.
Okay, serve the local representative if there is one.
If no agent and you know their foreign address, you send the summons there by registered mail.
Makes sense, direct mail if possible.
Only if there's no agent and their foreign address is unknown can you resort to publishing the notice in Ethiopian newspapers.
Newspapers in the foreign country.
Generally, no, Sedler explains. If the address is unknown, how would you know which foreign country or newspaper to publish in? So publication happens within Ethiopia as the final fallback for unknown foreign residents.
Okay, that covers the whole hierarchy. Now, the critical part. What happens if this process isn't followed correctly? Lack of proper notice, as Sedler calls it.
Yes, this is crucial. Sedler distinguishes between simply failing to use the absolute best method, which might be a procedural flaw, and providing legally insufficient notice.
What's the difference?
Legally insufficient notice is using a method that's clearly unreasonable when a much better, obvious method was available. He brings up that American case, Walker v. City of Hutchinson, where just using newspaper publication for a known property owner was found to violate due process and voided the judgment. Sedler suggests a similar outcome might happen under Ethiopian law in extreme cases.
So a really bad failure could void the whole thing. But just using, say, constructive service when personal service might have been possible isn't automatically fatal.
Not necessarily fatal to the court's jurisdiction, no. But it creates problems. Imagine the serving officer leaves the summons with the defendant's son, even though the father was easily findable. The son forgets to give it to him. Father doesn't show up in court.
Right. So was the father duly served? That becomes the question, especially for things like ex parte hearings, Article 70A, or setting aside an ex parte judgment, Article 78.
Exactly. Article 78 allows the defendant to ask the court to set aside an ex parte decree within a month of finding out about it, if they can show the summons was not duly served.
And Sedler discusses 2 ways to interpret duly served, in light of the service hierarchy, right? Directory versus mandatory.
Correct. The directory view says the hierarchy rules are just guidelines. As long as the method used, like serving the son, was reasonable overall, service is valid, even if personal service was skipped.
Okay, a more flexible approach. What's the mandatory view?
The mandatory interpretation, which Sedler himself favors, says the hierarchy rules must be followed strictly. If a better method was feasible but not used, service was not duly served.
And what are the consequences of that mandatory view?
Under this view, if the court knows service wasn't done by the best feasible method, it shouldn't hold an ex parte hearing. And if it issues an ex parte decree anyway, it should set it aside if the defendant makes a timely motion under Article 78, arguing they weren't duly served.
Why did Sedler favor this stricter interpretation?
He felt it better protected the defendant's right to the best possible notice and a real chance to defend themselves, without usually causing major problems for the plaintiff, who could just be ordered to reserve properly. It also discourages cutting corners on service.
A stronger protection for the defendant's rights. But there's a huge exception to this, isn't there? What if the defendant finds out anyway?
Exactly. This is key. Sedler stresses that if the defendant actually received notice of the suit, they generally can't complain later that a technically better method wasn't used.
So actual knowledge trumps procedural defects in the method.
Pretty much. The whole point of service is notification. If the defendant knows about the suit, the purpose is fulfilled. Requiring re-service just because, say, they got it from their son instead of directly when they did get it would be pointless delay.
So in that example where the summons was left with the son, if the son did give it to his father, the father couldn't later claim improper service just because personal service was skipped.
Correct. He knew about the suit. Now, Sedler does add, if the notice arrives so late he didn't have time to prepare, he might get a postponement. But the service itself wouldn't necessarily be invalid just because of the method used, given his actual knowledge.
That makes practical sense. You can't ignore a lawsuit you know about just because the delivery wasn't textbook perfect. Sedler even applied this to the Walker case.
He did. He noted that even though newspaper notice was deemed insufficient in Walker, if the defendant had actually seen that newspaper notice, they likely would have been obligated to appear and couldn't have claimed a lack of notice just because mail wasn't used. Actual knowledge is powerful.
Okay, so let's pull it all together. What are Sedler's main points on lack of proper notice?
Okay, summarizing Sedler's analysis from 68. First, actual notice cures defects in the method of service. If you know, you know.
Yeah.
Second, if there's no actual notice and a less effective method was used when a better one was feasible, then the summons likely wasn't duly served.
Meaning ex parte proceedings might be improper.
Right. The court shouldn't proceed ex parte, and if it does, the decree should be set aside if the defendant files a timely motion under Article 78 within a month of learning about it.
Okay. Oh.
Third, this failure to follow the hierarchy without actual notice is a procedural irregularity. The defendant has to raise it via that Article 78 motion. If they don't, the decree usually stands, even if service was initially flawed.
So you have to act fairly quickly once you find out.
Yes. And finally, he distinguishes all this from legally insufficient notice, using a method so unreasonable it violates due process, like the Walker scenario. That kind of fundamental flaw could potentially void the judgment entirely, challengeable at any time, not just within the Article 78 window.
A crucial distinction between a procedural slip-up and a fundamental denial of rights.
Exactly. And Sedler's overall conclusion is that courts really need to insist on strict compliance with the Code's service rules to ensure fairness and the best possible notice.
That's a really clear picture of how complex yet important getting that initial notice right was, and how the system tried to balance everything.
It really was a careful balancing act, as Professor Sedler laid it out. Ensuring people knew they were being sued was fundamental.
Well, that wraps up our deep dive into instituting suits and serving process in Ethiopia, circa 1968, guided by Professor Robert Allen Sedler.
We've seen the emphasis on adequate notice, the opportunity to be heard, and that whole structured hierarchy of service methods designed, at least in principle, to achieve that.
It definitely leaves you thinking, though, how do these principles from, over half a century ago, based on Sedler's analysis of that specific time and place, compare to today? Especially with everything digital.
Right. How do we serve process effectively now? What challenges does the internet, email, social media pose? What parts of Sedler's analysis about fundamental fairness remain timeless, and what's had to drastically change?
That's the provocative thought for everyone listening. What's fundamental and what's evolved? Thanks for joining us on this deep dive.
Yes, thank you. And if you have source material you think warrants its own exploration, do send it our way.
Until next time, thanks for listening.